The House will come to order. The Pledge of Allegiance this morning will be led by Christiana Bentley, Skylar Van Meter, Craig Patterson, and Emma Sheffield from Pine Lane Elementary School in Parker. There we go. Who wants to?
Okay. Please join us in saying the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Cole, please take the roll.
Hey guys, hold on. Skylar.
Representatives Becker,
Christiana.
Buck, Buckner, Conti,
Guys, do you guys want
Quorum,
to take a picture?
Yes.
Court,
Let's do this.
Del Grosso, Dorr, Duran, Everett, Exum, Fields, Fisher, Foote, Garcia, Gardner, Giroux, Janal, Hamner, Holbert, Hollinghorse, Humphrey, Joshi, Kagan, Kraft-Tharp, Labuda, Representative Labuda, Landgraf, Lawrence, Lebsock, Representative Lebsock, Lee, May, McCann, McLaughlin, McNulty, Representative McNulty, absent, Melton, Mitch Bush, Moreno, Murray, Navarro, Nordberg, Pabon, Peniston, Pedersen, Primavera, Priola, Rankin. Representative Rankin is here. Rosenthal, Ryden, Sane, Representative Sane is right there. Yep. Salazar, Schaefer, Scott, Singer, absent. Singer excused. Sonnenberg, Stevens, Swam is excused. Zabo, Tyler. Okay. Representative Tyler. Representative McNulty is excused. Representative Vigil. Waller. Williams. Wilson. Wright. Young. Speaker Ferrandino.
That's here with Lila speaking. 62 and 3. What? 62 and 3. Can I have this for a second? Thank you as you mess it up. With 62 members present, 3 excused, the quorum is present. Representative Primavera.
Mr. Speaker, I move that the reading of the Journal of Tuesday, February 11th, 2014 be dispensed with and that be approved as corrected by the Chief Clerk.
You've heard the motion. All those in favor say aye. Aye. All those opposed, no. No. The motion is adopted. Announcements and introductions. Representative Ryden.
Thank you, Mr. Speaker. Members, if I could have your attention for just a brief moment. Hello. Thank you, members. Members, I think you might have seen on the news or read in the paper that a person got lost out in the eastern Colorado somewhere, and people were trying to find him, and it was a Civil Air Patrol plane who spotted this gentleman in his SUV out in the middle of a field and was able to get help to him. And so that brings up our own Civil Air Patrol memberships here, and I've got cards and I'm distributing them to members who have signed up. And if you do not get one, see me if you would like to be a member of our Civil Air Patrol. It's a wonderful organization and something that I think we all support. So thank you very much.
Representative Corr.
Thank you, Mr. Speaker. Members, this evening, Colorado Motor Carriers having a reception history at Colorado from 4 to 6:30. Truck on over there.
Representative Moreno, will you be there? Representative Rosenthal.
Thank you, Mr. Speaker. Members, I have 3 guests from Southeast Denver today from House District 9 who I presented commendations to for their work, lifelong work, 2 of whom are former members of this body who are now retired. It seems like House District 9 is the place that members go to retire, so you're all welcome to move to House District 9. And they're here with their families. The first is State Representative Ruth Prendergast. Ruth, would you like to stand? And Ruth has been very active in the Republican Party for many decades. She was chair of the President Reagan Committee in Colorado and served in this body from 1980 to 1984. And we said the pledge this morning. It's partly due to Ruth because she kept introducing a resolution saying we should do the pledge. So let's thank Ruth anytime we do the pledge. Next we have State Representative Alice Borodkin. Alice, where are you? And Alice was a member from 2001 to 2009. She was a pioneer on the human trafficking issue. She introduced the very first bill on that topic. And she's also from House District 9. And recently, after the legislature, she formed Women Engaging Globally. And as you see, members are still active once they leave the legislature. So hopefully all of you will still be active as well. So let's give her a hand. And finally, we have a local attorney who's also very active in our area with Friends of Denver Parks. So I also presented him as well. Thank you very much. So members, thank you, and let's welcome our friends.
Representative Rosenthal, that'll be $5.
Only $5?
Members.
And I didn't say my name.
It doesn't matter, still $5. You skirted the rules.
I thought we were not supposed to say
Oh, you went way over.
That's fine.
Representative Holbert.
I only have a 20. I'll get a picture later.
Thank you, Mr. Speaker. Good morning, members. If I could have your attention, please. Pine Lane Elementary School is in the house. If you could all turn to the balcony and wave to the kids from Pine Lane Elementary School in Parker, Colorado. Thank you for being here. You're awesome. Some of their classmates offered the pledge this morning. I also have the opportunity to introduce a group of adults over here on my right, members of the Colorado Mortgage Lenders Association, including members of their Future Leaders program. They're here to meet their legislators and understand the process. If you all want to stand up, everybody give them a hand, and thanks for being here and being part of the process.
Representative Ken.
Thank you, Mr. Speaker. Mr. Speaker, I would ask to be excused on Friday and Monday of next week. I have talked to the minority leader and the majority leader, and they have approved.
Representative McCann will be excused as requested. Representative Navarro.
Members, just a reminder that today at noon we're having the Behavioral Health Caucus. I would appreciate all of your support if you could come down and hear some important issues. Thank you.
Representative Labuda.
Thank you, Mr. Speaker. Next week, members, I won't be saying this, but remember, Friday is Valentine's Day. That morning at 8 a.m., room 109. The Women's Caucus is going to be joining there, invites everybody to come and welcome our two new members, as I keep saying, Representative Becker, whom we all know here, but we may not know Senator Zenzinger, who's in the Senate. Thank you.
Representative Giroux.
Thank you, Mr. Speaker. Colleagues, if I could have your attention, I want to announce this mug is for you. The Junior League of Denver, and I'm a former junior leaguer. Okay, go make your fun jokes. Go ahead. Members of the Junior League of Denver are hosting a legislative breakfast tomorrow morning. That's food. You guys love food. It'll be from 7:30 to 9 outside the old Supreme Court chambers, and they'd love for you to all come visit. You may remember the Junior League has been active in the Denver metro community for nearly 100 years, and no, I was not the first member. So please stop by tomorrow and learn about their latest community investments. Y'all come.
Representative McLaughlin. Ann Hamner.
Thank you, Mr. Speaker. We want to remind the members again that tomorrow at 7:30, Western State Colorado University is hosting a legislative reception at 7:30 in the morning. We'd love you to come learn more about Colorado's most beautiful mountain college.
Thank you, Mr. Speaker. And even though Western State isn't exactly in my House district, they've sort of adopted me along with Representative McLaughlin to help promote the event and support the great work going on in Gunnison, Colorado. We hope that you join us tomorrow morning. It's in Senate Committee Room 354, 7:30 a.m. See you there.
Representative Murray.
Thank you, Mr. Speaker. I request to be excused tomorrow at noon through Friday. I have visited with the Majority Leader and the Minority Leader, please.
Representative Murray will be excused
As requested.
Thank you.
Any further announcements or introductions?
Representative Fisher.
Thank you, Mr. Speaker. Members, we're a little bit late in getting word out about this, but I'd like to bring to your attention that the Foundation for Water Education will be holding a Water 101 seminar on the Colorado Water Plan a week from today at noon up in Senate Committee Room 356. And this is a topic of real interest and importance to the state of Colorado. So I would like to just get this on your calendar. If you could pencil in Wednesday at noon on this, February 19th. Please hold that date on your calendar, and I'll be back with more information later.
Is there any further
Announcements or introductions? Seeing none, members, please return to your desks. We will proceed to the next order of business. Third reading of the bills, final passage. Members, please return to your desks, including you, Representative Waller. I always know where to find you, Representative Waller. You're always sitting at the press table. Representative Waller.
Thank you, Mr. Speaker. I feel I have to defend my honor here. Little known fact that I am perhaps
You're taking a moment of personal privilege?
I'd like a moment of personal privilege, Mr. Speaker.
A moment of personal privilege.
Thank you, Mr. Speaker. You know, it might not be well known in this body, in this chamber, but I do happen to suffer greatly as a Chicago Bears fan. Well, all right, I get it. And yesterday, I was punked by a member of the esteemed media here in the Colorado General Assembly. Ivan Moreno sent me a text message saying my beloved quarterback, Jay Cutler, had in fact been traded to the Dallas Cowboys for Kyle Orton. Yes. And I got to tell you, he had me just a little bit. Just a little bit. I discovered that I was punked, and so I felt like I had to defend my honor with the media today. That's why I was over at the media table clearing up any issues we might have related to Jay Cutler and Kyle Orton, Mr. Speaker.
I look forward to every day your explanation of why you're at the press table. Mr. Kohler, please read the title of the House Bill 1065.
House Bill 1065, Representative Moreno, Senator Hodge, concerning limits on indemnification provisions in motor carrier transportation contracts.
Can I have a majority leader? One of them? Mr. Assistant Majority Leader.
Thank you, Mr. Speaker. I move for the adoption of House Bill 1065 on third reading and final passage.
Seeing no
Discussion. The question before the House is
the passage of House Bill 1065 on third reading and final passage. Mr. Kohler, please open the machine and members proceed to vote.
Sorry.
No. He was just making sure someone was in the system.
I got you.
Representative McLaughlin.
That.
Close the machine. With 41 aye votes, 23 no votes,
1 excused and 0 absent, House Bill 1065 is passed. Co-sponsors.
Close the machine. Mr. Kohler, please read the title to House Bill 1099.
House Bill 1099 by Representative Schaefer, also Senator Aguilar, concerning prescription drugs and the practice of optometry.
Mr. Assistant Majority Leader.
Thank you, Mr. Speaker. I move for the passage of House Bill 1099 on third reading and final passage.
Seeing no discussion, the question for the House is the passage of House Bill 1099 on third reading and final passage. Mr. Kohler, please open the machine and members proceed to vote. Representatives Fields, Hollinghorse, Swam. Madam Majority Leader. Close the machine with 64 aye votes, 0 no votes, 1 excused, and 0 absent. House Bill 1099 is passed. Co-sponsors. Close the machine. We'll proceed to our next order of business, general order, second reading of bills. Representative Salazar.
Mr. Speaker, I move the House now resolve itself into the committee of the whole for the consideration of general orders.
You've heard the motion. Seeing no objection, the House will resolve itself in the committee of the whole for consideration of general orders. Representative Salazar will take the chair.
Committee will come to order. With your unanimous consent, the bill will be read by title unless there is a request for a reading of bill at length. It's on. It's not working.
Yes.
Well, how are you? Oh, it's been a while.
Afterwards? Thank you very much. Hello. There we go. There we go. Okay. Thank you, Representative Gardner. With your unanimous can you hear it? Hello. Hello. Yeah, that's what it is. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee amendments will not be read unless requested, as they are short now. Committee will stand in recess.
Test. Test 1, 2, 3. There we go.
Hello?
Gotta come back to order. Chris.
The committee will.
I forgot it's not. We can pull this. Okay, so let's go ahead. You want this pulled?
unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee amendments will not be read unless requested, as they are printed and in your bill folders. Floor amendments will be shown on the screen and not read unless requested. Bills will be laid over upon motion of the Majority Leader, and the coat rule is relaxed. Mr. Kohler, please read the title of House Bill 1110.
House Bill 1110 by Representative Peniston, also Senator Hodge, concerning procedures governing discussions of boards of education of school districts while meeting in executive session.
Please note that House Bill 1110 has previously been amended on February 11th, 2014. Representative Peniston.
Thank you, Mr. Chair. I move House Bill 1110 as amended. We have had a renewed fiscal note, didn't change a thing, and so we had a great conversation. So I ask for your yes vote on 1110.
Is there any further discussion? Seeing Representative Gardner.
Just to kind of recap what the bill's about. We want transparency for some people.
Thank you, Mr. Chair. Well, members, we're back on this bill. Let me point out to you that the amendments, or amendment, I think it was a single amendment that passed. But as you consider this bill, consider the amendment that did not pass, the lack of that amendment, because the amendment that did not pass was an amendment that would have created transparency for school boards engaging in union negotiations. And that was rejected by many of you. And I don't expect in my hour of discussion down here to change many minds, but we do have to do what we can do. And if a colleague would bring me Title 24 of the Colorado Revised Statutes, I will endeavor to review that so that people understand how this really works in Open Meetings Act. Because one of the things that concerns me as we vote on things here is that people don't really understand how things work in action out there in the real world, how your elected officials, your local elected officials, your school board members who do not have any pay as you do, any per diem as you do, they're just trying to deal with this issue. And what this bill does, even as amended, is require school boards first to make a recording of those conversations with their attorney, and that's not currently the case. So when people talk about here in the well about this is just a little change or it only requires them to do what they're already doing, it requires them to do a very different and critical thing. Very different. If it was, you know, people come down to the well and they say, oh, this is a little change, it's not really different, this is the law anyway, or something like that. You know, it always irritates me. Because if that was really the case, we wouldn't need the bill. This bill is, members, what seems, for my friends on the left, to become your mantra in committee these days. This bill is a sea change. It is an attack. It is an attack by a particular group upon attorney-client privilege. And for those of you who are members of the bar in this chamber who are going to vote for this bill at the risk of being gavelled let me just say, shame on you. Shame on you for requiring the abrogation of the attorney-client privilege. Now, my friend and colleague, Mr. Chair, who was not in the chair the other day, came down and said, well, the attorney-client privilege gets abrogated all of the time. Well, it doesn't get abrogated all of the time, and maybe that's an overstatement of what he said, but when it's abrogated, it's a big deal. And it's not abrogated voluntarily. It's, as I said the other day, much to the horror and chagrin of the attorney involved, it is abrogated inadvertently or negligently or carelessly. And courts do not take that lightly. But what this bill does is say, we're going to record this, we're going to record all the conversation. So the way this works in the real world is today, when an attorney advises a school board in an executive session, and they go into executive session by a 2/3 vote, that's in 24-6-402. They take a vote to go into executive session. Now, they have to record all of their executive session with a single important exception. And that single important exception is that when their attorney is present, and when their attorney states in his or her opinion that the conversation about to be conducted will be attorney-client privilege due to legal advice, discussion of litigation, discussion of negotiation, and I'm about to give legal advice, says the attorney on the record. You may turn off the recorder. Now, the lay people among you may say, well, so you record everything else, why not that? Well, in our Western Anglo-American law and jurisprudence, we recognize some privileges as near absolute. Your privilege in the confessional is near absolute. It's probably as absolute as any ever is. Your privilege when you sit as an individual or a corporate body sits with their lawyer and requests advice or receives advice even if they didn't ask for it. I don't know if any of you lawyers have ever had that case. They didn't ask for it, but I feel compelled to give it to them. Something like, don't do that, that would be a violation of the law. Don't do that, you risk litigation. Don't do that, it's legal, but it looks bad. Difficult to defend at the courthouse. Or, you know, the really best course of action here is to get this behind you. And so, when that attorney sits with the school board, today that is not recorded. What this bill does is say, you have to record it. And I think the proponents would say, well, but if it's really attorney-client privilege, it'll never be released. Well, the thing that does have to be released is the subject that was discussed and the time spent discussing it. Now, Attorneys, have you ever stopped to think that the very fact that you have someone as a client not often, I say not often in my practice, but perhaps in some of your practices, the fact that you even have someone as a client can be privileged. The fact that that client even needs legal advice. The fact that the client even asks you about the issue can be privileged. And it could be damaging that you ask. What does this bill do? It requires a log with the amount of time spent discussing something and what that topic is. I can see litigation over whether that log itself was specific enough. And my friend, Representative Peniston, who's not an attorney and feels like this is a David and Goliath fight, I see she's got two Goliaths here to wage battle for her. And I stand here alone. I'm not sure who David and Goliath is in this case. But members, let's just think about it for a moment. I'm a school board member, and it comes to my attention that the school that I am elected to serve and represent may be engaged in a practice, maybe with respect to employees, maybe with respect to special education, maybe with respect to the operation of their building, and have nothing to do with the actual education going on. And a constituent brings it to my attention, and I sort of listen, and I don't make a big deal, but I think there could be some risk there. So what I do is I make a request to the board president, or however that is done, that perhaps the attorney for the school could come and provide advice to us. And I don't want anybody to know outside of the school leadership what that issue is. Why? Because I'm a bad public official? No, because I think that the risk to the taxpayers and citizens that we serve and our ability to provide education is astronomical. And so I ask to consult with the attorney in executive session with the entire board. And we have to make a log of that all of a sudden. Now, how does that work? What would I advise my school board client? Well, I'd probably advise them that they put on the log that we discussed risk management for an hour. Well, I think we just opened the door to litigation for whether or not risk management was a sufficient description. And I don't think under this bill, others may say otherwise, but I don't think under this bill that risk management would be sufficient, because I don't think it meets the requirement of the bill. So we have potential litigation about the description of what we discuss. Now, you know, I know this would be hard for all of you in this chamber to believe, but in some of my past lives, I've been sort of a thorn in the side of elected officials. I know that's hard for you to imagine, that I would ever have been a thorn in. the side of elected officials. But I have been. And if I saw the minutes of an executive session with an attorney-client privilege that says they spoke for an hour about a generic term like risk management, I think I, as a citizen, would be wondering what they spent so much time on discussing risk management. And I would contend at the courthouse, under this process where you can challenge them and get an injunction, I would contend that the school district ought to have to be more specific. And I would hope that a judge would agree with me under this bill. I think it's bad public policy, but this body makes public policy. It's not for judges to ultimately decide on things like that about what's good or bad public policy. I've seen them in these open meetings and Open Records Act cases say, well, I don't know that that's really all that good, but that's what the legislature has said we must do. And so I must do it. And if they do otherwise, we stand here in the well and say that they're taking the law into their own hands and being activist judges, and we wouldn't want that. So I have an hour recording out there on risk management, and I'm not just a random gadfly for the school district. I really do have an issue with them. I have an ongoing complaint that I've had, and I wonder if they discussed my issue. Are they worried? Are they getting advice? When I talk to the school board members, they act like they're unconcerned. But maybe they're very concerned. Maybe they've been told by their lawyer, you know, don't let on, we've got some risk here. So the very knowing that they discussed my complaint or the issue about which I was concerned may tell me, and if they talked about it a long time, may give me an indication that they're very concerned. Now, again, the laypersons among our body may say, well, so what's the big deal? Well, you know, one of the reasons for the attorney-client privilege is so that people will get legal advice. The reason we observe the privilege of the confessional is so that people feel free to confess. And the reason that we observe the attorney-client privilege, among others, is so that people will seek proper legal advice, and presumably and hopefully, when they see my friend Representative McLaughlin and they're on a wrong course and they're about to commit a crime, I know my friend Representative McLaughlin would say, you know, if you do that, it is a violation of law. And the penalties for that are whatever they might be. And so it is my very strong advice, says my friend Representative McLaughlin, that you not engage in that course of conduct. Now, we can get further into this over the next 50 minutes or so. We can get further into this and discuss whether that school board has a school that's violating, say, an environmental law. It's not hard these days. Whether they decide to persist in the practice, whether it's the obligation or whether or not someone like Representative McLaughlin might actually be able to report them. There's a lot of case law about that. And if someone relieves me here, I'll go look it up and I will talk to you about it. It's a couple of hours in law school. so that you fully understand the attorney-client privilege, because that's what we're abrogating here. That's what we're abrogating. And what it means, what it really means, is that school boards will not seek legal advice. And when I sit with the school board and give them advice, and we come to that moment in time when I want to say to them, look, this is a very serious matter. There's very high liability risk here. Maybe it's an environmental thing where really good people may find themselves having violated a strict liability law. I may want to say to them, you have got to quit this and we've got to figure it out, and we may need to make disclosure. Because one of my responsibilities is to figure out whether they might need to disclose to the authorities in a context that they would not be prosecuted. Now, does this bill, when it requires me to keep a log, do I have to be so specific as to say potential disclosure of criminal violations? Well, I think some would argue that that would be the case. And when they get to the courts, a judge, and there are many judges around the state, the vast majority of them being highly competent, highly respectful of the attorney-client privilege. But what this bill contemplates is that that recording would be listened to by the judge. You say, well, let's trust our judges. Well, it's not that I don't trust our judges. It is that no one other than the attorney and the client should ever hear that conversation. The existence of that recording is itself a significant risk to the attorney-client privilege. Because one judge who may hear that a school board is getting advice about a potential criminal violation, and again, I want to use the example of an environmental violation because those can happen. School facilities and others can violate the law and not really have any bad intent, not know that they've done it, and yet it can expose them to serious criminal liability. And a judge hearing that a lawyer just said, you know, you guys are violating the environmental laws of the United States and the state of Colorado, and you could all go to jail for a year. And if the school, wrong-headedly perhaps, says, well, we're going to keep doing it, or if the school perhaps says, well, we're not able to stop doing it. It will cost us $1 million to fix our hazardous discharge problem. And we're going to have to figure out how to get that $1 million. And it's not exactly like we can go for a mill levy override or a bond issue or something for something so we quit a violation of law. Or if we do, we want to tell the public about it carefully. You know, you got to start feeling sorry for these school board members who find themselves in such situations, and they do from time to time, because all they wanted to do was try to help their children. So that recording, to come back to the recording, exists, and a judge hears that recording. Now, I'm going to make a confession of my own here. Well, you'd think you could get people's attention whenever you stand in the well and say you're going to make a confession of your own. When I advise clients over the course of an hour in my attorney-client privilege communication with them, I talk to them about some things that are very legal. If it's an elected official, as I have from time to time, I have elected official clients, I may talk to them about things that are very political about their situation but not legal. And I may talk to them about the weather. I may digress in my conversation. Now, I know that all of you would be just very shocked to know that I might digress in a conversation from the topic. But that might happen when I'm talking to a client for an hour. And if you listen to the recording of that, if you were a judge listening, then you might be inclined to say, well, the Colorado General Assembly has passed this law that says you have to record attorney-client privilege communications. I have to record all of it. And I, as a judge, I have to discharge my obligation, and my obligation is to determine whether or not the attorney-client privilege was observed. Now, if I were a district court judge, I would be very disinclined to listen to the recording. I don't know if legally one could make me listen to the recording if I were a district court judge. I would simply call the lawyer in as a member of the bar, and I would ask him or her, counsel, was that an attorney-client privilege communication? Yes or no? Maybe I'll put him under oath. And if the answer is yes, I'm done. It is not for me. It is not for anyone else. And members of the bar over here, really, is it for someone else to decide when you're sitting with your client, giving them advice? Is it someone else's call as to what you're doing and the words that come out of your mouth and the exchanges you have with them, whether or not they're attorney-client privilege? I started to say rule of thumb, but rule of thumb is not what it is. My default rule, and the one that I have to convince myself isn't the case before I disclose something, is every conversation I have with a client is an attorney-client privilege communication. To the point that I have had to ask myself occasionally whether standing at a cocktail party at a wholly unrelated event, when that client talks to me, I have to ask myself, was there anything said there that had anything to do with my representation, or did we just talk about our kids' soccer game, or our work on a charitable event, or our work for a community event? The default position is any conversation I have with a client is attorney-client privilege. And I think my friends over here who are members of the bar would have a hard time arguing with that rule. Because believe me, the last thing a lawyer ever wants to do, Mr. Chair, is find themselves in the position where they have involuntarily abrogated the attorney-client privilege. You know, Mr. Chair, I knew a lawyer who did that one time. He wasn't disciplined for it that I know of. His malpractice insurer had to pay a fair chunk of change because of it. And it certainly raises the question, if these conversations that I would have with the school board would be second-guessed by a judge, appealed to the state Supreme Court or Court of Appeals, and then the state Supreme Court. I'm sort of apt to wonder, what are these conversations I could have with a school board in an executive session as an attorney at a couple of $100 an hour, or $400 if you're from 17th Street, I guess. What conversation would I have with these school board members that wouldn't be privileged? What would it be? Because if it's anything about what we went into executive session for, it's privileged. You know, I'm just searching over in my mind because I have represented public boards and bodies over the years, and I just search in my mind about all of those conversations, which I'm not going to disclose to you, by the way. But I search and go over in my mind about them, and I think, well, how do they determine what I said to those 5 members as being attorney-client privilege? Sometimes a board member, while we're discussing a land deal or an employment issue or a number of things, sometimes one of the board members will say something to me which is wide of the mark, irrelevant, not material to the issue in which we discuss. So when they say that thing, and I say to them, well, you know, really that doesn't have anything to do with this issue, does a judge hearing that say, well, that's not attorney-client privilege because the lawyer said it didn't have anything to do with the issue? Well, surely that can't be the case. Surely that can't be the case. But I can see how it would be argued that that was the case. And what does that litigation look like in terms of its expense? Well, first of all, understand that there are let's call them educator associations. I don't want to use the pejorative term union. Educator associations that may well have a very strong interest in knowing what's going on in a particular school district in a particular area of our state. I don't want to say exactly where because that would seem inappropriate. So I won't say Douglas County. I'll just say someplace out there in Colorado. And that association of educators may use their resources to challenge each and every use of the privilege and each and every time that an hour-long discussion is had about that, because I think these discussions probably have taken place, legitimately so. And I want to think about that a little more. Yeah. But what I find, members, is after I'm here a while, if I've not had my second cup of coffee, my energy level just starts to drop a little bit, and instead of being able to go for 2 more hours, I may only have another hour in me. And so, for that reason, I'll let someone else be recognized this morning, and I will talk to you a little more later about this question and issue of a school district being liable for endless litigation and challenge of its use of the privilege, and how it may cost them hundreds of thousands of dollars. Thank you, Mr. Chair.
Representative Gardner, you are a talent, and I mean that in the best sense. Representative McLaughlin.
Thank you, Mr. Speaker. Members, I rise in strong support of this bill. As we expressed at the last conversation about this bill, the public does not like secrecy. The public does not support secrecy in any governmental body. That is the purpose of the Sunset Law, the Open Records Act, and the other legislative enactments which have tried to make government more transparent. One of the opportunities that exists in existing law is that the attorneys for public bodies can utilize the attorney-client privilege as a mask of secrecy over actions taken by boards during executive session. We look at the outside world, outside of our legislature. We look at the business world. We look at the government world. No major corporation has an executive session without recording the entire contents of that meeting. The Joint Chiefs of Staff for the United States Armed Forces have executive sessions, and they record the contents of those meetings. That is because the intent is to ensure that if the record is examined, that the law has been complied with and that the purpose of the executive session has been properly fulfilled. I want to tell a little story. I told you on the last occasion when we discussed this bill that I had in fact represented both as county attorney and also as school board attorney and had dealt with this issue. Again, no public lawyer doesn't struggle with the public obligation to ensure that the public trust is fulfilled. When you work for a school board or when you work for a county, you just don't work for the majority of the membership who hired you. You are much more than a hired gun. I had a situation after I had been off the school board attorney for a number of years where I was contacted by a member of the school board. And the member of the school board had a complaint which related to the conduct in an executive session. That was by virtue of the fact that she was excused from the executive session, even though a member of the school board, because the school board wanted to discuss the dismissal of her son from the high school. So she hired me to find out what happened during this executive session. Mind you, this hysteria about the courts supervising the attorney-client privilege. Every attorney-client privilege issue is resolved by the courts, and this statute is no different than any other challenge to the attorney-client privilege, because whether the attorney-client privilege is asserted, the court must look at it and determine whether it applies or not, and then the matter will be excluded from public discourse and public disclosure. In this particular instance, with my school board member and her son having been expelled, we went ahead and made a request because at the time, and I think they still continue this, our school board recorded all executive sessions, as did our county. We went through the procedure. We showed cause to the court. The court issued an order. The court examined the executive session tapes in camera or on its own. They were never disclosed to us. The court determined that the attorney-client privilege did not apply, but the court also determined that there had been no violation of the law, which would give this school board member a claim. That's what happens when the court supervise the attorney-client privilege. Again, I support this bill because it will increase transparency in government. And you know what? When people know that what they're saying and what they're doing is being recorded, it brings a higher level of honesty and disclosure. We have already seen in our history examples of when things are recorded, we get the true statement of what occurred in the executive office. We get the true statement of what occurs in these closed-door meetings. So to ensure public transparency, to ensure that the executive sessions are properly applied, this is why we need to adopt this statute. I ask your strong support for this bill. Thank you.
Representative McNulty.
Thank you, Mr. Chairman, and thank you, Representative McLaughlin. I think the question that we ought to ask, and I don't recall this question being asked the last time we debated this bill on the floor. It was asked in committee. We have not had the discussion on the floor. Representative Peniston, you have made it absolutely clear that this bill is not designed to target any particular school district. And certainly you've always been known to me as a woman of your word, and I take you at your word. I will say, though, that the testimony that was offered in committee painted a much different picture. The testimony that was offered in committee was clear that this bill is targeted at and punitive to a few school districts in this state, and that's unfortunate. We should not use the power of legislation, our power to introduce bills, to punish. And that's what's happening here. It almost appears as though this bill is an attempt by some to relitigate the elections from last November. And that's sad. It's not fair and it's not right, but it is the position that we're in today as we consider House Bill 1110. There is a very credible argument, a very fair argument, a very real argument to be made that this bill upends attorney-client privilege, and that it does so in a way that is very dangerous for those who find themselves in need of legal assistance and for lawyers, for attorneys who are in the practice. Representative Gardner has made those examples, those situations, the consequences therein absolutely crystal clear. And I know that those of you who do practice law understand the significance of the attorney-client privilege and understand the weight of that obligation that you carry. The state should not come in and say, Representative Pabon, because you are representing this one particular public entity, your attorney-client conversations are going to be recorded and may be disclosed. Now, keep in mind, Representative Pabon, that as you represent many different state agencies, as you represent even this, the Colorado General Assembly, your attorney-client privilege isn't subject to the same requirements under state law. But if you represent a school district, your attorney-client privileges are then recorded and potentially made available to the public. It undermines the attorney-client privilege. It undermines an attorney's ability to represent his or her client and undermines our ability to conduct ourselves in a way becoming of the Colorado House of Representatives when we see bills like this coming forward that are exclusive in their punishment, and designed to litigate elections past. Colleagues, I ask for a no vote on House Bill 1110.
Representative Priola.
Thank you, Mr. Chair. Members, I rise in strong opposition to House Bill 1110. I can't believe how obvious a target of this bill is of certain school boards in this state because the fact that elections were won by pro-reform folks in this state Representative Penniston has the audacity to come down here and try to change the rules of the game for a certain segment.
Representative Priola, let's not veer too close to impugning the motives of the members, please.
This bill only touches on executive session for school boards, not executive session for the rest of the state statute. We've all seen the YouTube videos. We see where the battlegrounds are now for reform in the state of Colorado in education. There are entrenched interests that do not want reform. They do not want to reform education in the state of Colorado. And they are losing at the ballot box, and they are using
Representative Priola, to the bill, please.
To try to stop it.
To the bill, please, Representative
This
Priola.
is directly to the bill. I would be ashamed to run something this overtly targeted at stopping the good works of those who are trying to educate the kids in the state of Colorado. This, in the end, will only encourage more litigation, will take more time and resources from our kids, take more money out of the classroom. This is not too similar to other bills that have tried to game the system. What is the problem we're trying to fix here? I would like to hear that from the sponsor. In committee, she said, well, that there aren't exactly any situations to speak directly to, but there have been accusations. What is the problem? How has this happened time in and time out for years and decades that now we need to come down here and target a specific area of statute, executive order, executive session only for school boards? It does not respect local control in the state of Colorado. There's no provision here for a school board may or may not do this. We have to. We've heard some say, oh, some school boards already do this. Well, fine. Fine. Maybe they're fine with doing it. Why not offer that amendment on this bill? But no. This is about creating litigation, creating news stories, creating a witch hunt, creating a fishing expedition. This pierces the veil of attorney-client privilege, specifically in this area of statute in school board executive session. And I wish I could go on, as my colleague Representative Gardner, to stress that point. I think he did a masterful job of stressing that point. That's exactly what this bill does. Let there be no doubt. I would love to hear from Representative Pabon, who is concerned about attorney-client privilege and other issues. Or Representative Kagan, who's concerned about attorney-client privilege issues on other bills. But
speaking about this bill, Representative Priola?
Apparently not this bill, because this bill accomplishes other ends. And that's what has me so fired up about 1110. Let there be no doubt that in the coming years, this change in statute will be used. I want that on the record, because it will be. There will be increased litigation. There will be increased news stories for elections to try to shape public opinion and stop real reform that is helping increase knowledge and the education of our young in the state of Colorado. This bill isn't just a bad bill. This is a terrible idea, a terrible policy change. Please vote no.
Mr. Assistant Majority Leader.
Thank you, Mr. Chair, and my name has been brought up a couple of times down here as an attorney and a member of this body. And I want to address a couple of the points that were brought up by both Representative McNulty and Representative Priola. Representative McNulty said that this is a targeted piece of legislation to go after bad actors, and that's not allowed. That's illegal to have special legislation, as Representative McNulty knows, to have any sort of targeted legislation. So that's just flat wrong. With respect to Representative Priola's and Representative McNulty's and Representative Gardner's remarks about having double standards for when we record executive session, listen to this, members. When the legislature, when the legislative body, when the executive committee goes into special session and receives legal advice, guess what? This may be shocking breaking news, but that advice is recorded. So this is not having, unless those members who've served on that executive committee can tell me otherwise, some sort of chilling effect on the candor that exists between clients and their attorneys. But let's just say, for purposes of argument, that I do, in fact, want to make sure that that attorney-client privilege is protected and used only as appropriate under, not under statute, because statute is one thing. We actually have something, in my opinion, that's higher than statute, and that's our ethical obligations as attorneys. We have a responsibility and a duty to the profession, and we take a sworn oath when we become attorneys to uphold our ethical duties. Now, some of attorneys are better than others at upholding those ethical responsibilities, and that's a problem. What's even more problematic, though, is if an attorney breaches that ethical responsibility, there is no evidence that can be presented, again, to the higher body, which to me is the Colorado Supreme Court, the attorney regulatory body, to ensure that that attorney is held accountable. Because at this point, there's no recording, there's no log, there's no evidence to demonstrate that that attorney has breached their ethical obligations. And if we're going to be fair about providing the evidence that we need for that, that's what this bill requires. If the attorney has not violated their ethical obligations, there is no need to worry about whether or not these recordings take place. And it is what we call an in-camera review. A judge who, again, is sworn under his or her own oath to review these documents and review these conversations to ensure that they meet the contours of the privilege, as, again, we invoke under our ethical obligations. If there's no breach there, there's no disclosure. And I've had many hundreds of conversations with my clients under the privilege of attorney-client privilege. It is an important privilege. It's a sacrosanct privilege. It is the privilege that we have. I could not agree more with my friends on this side of the aisle with respect to that. But as with every privilege, there are some contours and there are some side rails that we need in place. And the worst thing that we could do to our friends in the bar, to our profession, our esteemed profession, as I still hope it is to breach those ethical obligations and have no accountability for that breach. That's why this is a good bill, and I wanted to address those statements made here in the well.
Representative Hamner.
Thank you, Mr. Chair. And colleagues, while I've enjoyed listening to the legal debate on this bill, my comments come from more of a practical level, on the ground perspective. I think most of you know I've spent almost my entire life working in the public education system. And I've had the privilege of working with school boards in executive session with attorney-client privilege. And I guess the reason I do support this bill is that, our school board members are citizens who are elected to represent the people and operate their meetings in the public eye. And when they go into executive session and when the tape is turned off, they're just human people, and they do need, from time to time, the attorney reminding them of what's allowable in that discussion in executive session when they're under attorney-client privilege. So one of the things that I think this bill will really help with is that if the entire proceedings are tape recorded, I think that helps every school board member hold him or herself more accountable to that attorney-client privilege and keeping the discussion within that parameter. The second reason I think this is a good bill is that it assures our public that when the school board does go into these executive sessions with their attorney, that if they have any reason to believe that the discussion has gone outside that parameter, they have, if they have a legitimate reason to question that, have the opportunity to put that question in front of a judge to determine whether or not the discussion that took place did fall within the attorney-client privilege. So I know you probably want to hear more of the legal debate around the bill, but I just wanted to offer a couple practical perspectives, and I hope that you support the bill. Thank you.
Representative McNulty.
Thank you, Mr. Chairman. Representative Pabon. Representative Pabon. I would agree with you. I would agree with an amendment that you might bring that would require all government entities to record their executive sessions and to have the same type of judicial review available for all of those. It is true that we do record our executive sessions here in the General Assembly amongst legislative leadership. We do not publish an agenda with time spent on each topic. If I were opposing counsel, Representative Peniston, as Representative Gardner has pointed out over and over again, a competent opposing counsel would look at the amount of time spent on each topic and start to pick and start to choose and start to fish. And that's the issue that we have in front of us here. I think that Representative Pabon, if you wanted to scrap yourself up a late bill title to require all public entities to record their executive sessions, I'd join you in that bill. I don't think that there is, as long as we're treating all equally and following the procedures that we follow here in the General Assembly, I think that is fair. It does not address the concerns that Representative Gardner has in total, but it would address some. So if the choice is between Representative Peniston's bill moving forward that I think is unnecessarily and unfairly punitive, or a broader bill that is not punitive, that addresses all aspects of government and public life in the state of Colorado, I think there's potential for some bipartisan agreement there, Representative Pabon. So I will leave that in your hands, Representative Peniston. This is your bill, and I suspect that you have the votes to pass it. But Representative Pabon, it's an open invitation to you to try and correct this, move it forward, and do so in a bipartisan manner. Thank you, Mr. Chairman.
Representative Gardner. Representative Wilson.
Thank you, Mr. Chair. I heard my colleague Representative Gardner's plea on David and Goliath, and I'm not an attorney, so I'm just up here as a small stone on the side of David here. There was a fleeting moment that I almost understood attorney-client privilege, Representative Gardner. So I, too, would echo what Representative McNulty said, that I don't understand why this bill is targeted towards school districts alone. I really don't understand that part, because basically in communities, people are elected to the board as far as the school board, the city council. They're just people. And if we need this transparency there on one board, we need it on all boards. personally, from my community experience, we've had more issues at the city council level than we had the school board level, but that may be just my community. As I said, I'm not an attorney. I am an educator, and I appreciate what Representative Hamner said from her perspective as an educator and being a superintendent and having been in those executive sessions. I may be more unique even than Representative Hamner in the fact that I'd been a topic of those executive sessions, and I know some of my colleagues may find this hard to believe, but I kind of get to be a lightning rod no matter where I go. And there was a point in my educational career when I was the negotiator for the association that my school board decided they might want to relieve me of my duties and send me on down the road. Well, I would have loved to have had that kind of transparency at that time so I could have sat in on those sessions to see what they were saying about me. Later in my career, having become a superintendent, I was on the other side and saw that actually that attorney-client privilege not only had protected me back many, many years ago, but also protected many of the people that were a topic of those discussions. So I've seen it from both sides. I basically think, colleagues, that this is a local control issue. We elect people at the local level to take care of local business and make those local decisions. So again, my question is, do we trust local school boards and not local elected boards at the city level, or do we trust the city boards and not the school boards? What I say, folks, if it's good for the goose, it's good for the gander, and I have 3 concerns on it. One is that testimony in the Education Committee clearly pointed out that this was an issue with a very small number of districts, and when I pressed the testimony, it was 3 districts out of 178. That's a minor number. Second of all, this should apply to all entities. As Representative McNulty was saying, it should apply to all entities. That's what the 24 code talks about. 22 code doesn't talk about the open sessions and executive sessions. It's 24 code. So it applies to all. And third, my third question would be, is this actually broken? Is it actually broken? My experience on the farm usually was, if it ain't broke, don't fix it. And I think unless we include all entities in this, that it is not broken and we should not fix it. And as Representative Gardner said in his earlier testimony up here, or his earlier statements, he said, even if you think this bill's a good idea, why doesn't it apply to all? And I would echo that. And as a small stone on the side of Goliath, I would say without that change that I would be against this.
Representative Gardner.
Thank you, Mr. Chair. Well, there have been a lot of complex and nuanced legal issues thrown about here since I last left you a few minutes ago. Representative McNulty raised a very legitimate concern about the purpose of this bill. And I believe that he is correct in stating that this bill is aimed at particular districts. Now, my friend and colleague, Representative Pabon, raised, as I say, a very complex and nuanced issue about whether or not this is special legislation. Well, you know, you can do things that are aimed at particular entities in the state because there's only one of them or two of them, or because it'll only get used in particular places. So this offhand, well, this is not special legislation, you know that's unconstitutional. That doesn't really answer the suggestion, but we do hear this, and since Representative Pabon raised the question of special legislation, it caused me to go to Article 5, Section 25 of the Colorado Constitution, where special legislation is prohibited, so that we all understand whether or not this is special legislation as opposed to just legislation motivated by something different. I think it's important for the General Assembly, the House, to understand. That provision says the General Assembly shall not pass local or special laws in any of the following enumerated cases. And I need to look here, and I want you to look with me. You can pull this up on your iPad or whatever. It's Article 5, Section 25. The following enumerated cases to pick it up. That is to say, this is kind of interesting drafting. That is to say, for granting divorces. So you couldn't legislatively grant a divorce for someone. It seems archaic. It is a bit, because we have so-called no-fault divorce in Colorado, so it wouldn't be that. Laying out, opening, altering, or working roads or highways. Now that's something that the public really, in special legislation would not like. In fact, it's been very controversial for those of you who live in a certain community.
To this bill, Representative Gardner, thank you.
Thank you, Mr. Chair. Well, I am to this bill. I didn't think that special legislation and the issue of special legislation had anything to do with this bill. I didn't think so. But when the very distinguished Assistant Majority Leader raised the question of whether or not this was special legislation, and that maybe Representative McNulty was asserting that, I felt it necessary for this body to vote intelligently about the matter, Mr. Chair, to understand what the term special legislation as it's used in Colorado means. And again, I didn't think that topic had a lot to do with what Representative McNulty was talking about, because he didn't make the charge that it was special legislation in the constitutional sense. Rather, my friend Representative McNulty was making the point that it was wrongly motivated. But the Assistant Majority Leader said, this is not special legislation. And it raised the question in my mind, is it special legislation? Because if it is, it's prohibited. And again, I think this is to the bill only because of the debate and where it has taken us, and taken us from the other side of the aisle, Mr. Chair. So, vacating roads, towns, plats, streets, alleys, and public grounds, you can't do that. Locating or changing county seats, that would be special legislation. Regulating county or township affairs. Regulating the practice in courts of justice, that's interesting. And on it goes. I think I'll cut you a break, Mr. Chair.
Thank you, Representative Gardner.
My pleasure, Mr. Chair, and a privilege to serve with you.
Same here.
Members, my point is, Representative McNulty never asserted that it was special legislation. He asserted that it was legislation that was motivated by a desire to punish certain school districts for their use of the attorney-client privilege.
Representative Gardner, let's not veer towards impugning the motives of the members.
I'm sorry, Mr. Chair?
I said let's not veer too closely to impugning the motives of the members.
Well, Mr. Chair, I certainly haven't attacked the members. I was simply trying to draw reasonable inferences from what they argued here in the well. I don't know what we've reached in this body. I may have to take personal privilege tomorrow morning to discuss the question of what is a reasonable inference, or how we understand, because if we can't draw reasonable inferences from what is said down here, Mr. Chair, I think we'll not be able to engage in debate for the next 84 or so days before the people of Colorado and discharge our obligations to our constituents. But back to the bill. I keep getting pulled off track by, and I apologize, Mr. Chair, but you distract me from the bill. You know, Representative McNulty and Representative Wilson have made a very important point here. this bill, at the very least, is directed to attorneys and school boards, and only attorneys and school boards. And I have to tell you, in my 8 years here, this debate about executive session and the recording of executive session and the treatment of attorney-client privilege things has always been a topic. I think every session. And frankly, those of us who believe in the attorney-client privilege have fended off the challenge every time. I believe, I don't want to believe this, but I believe, Mr. Chair and members of the House, that this is finally going to be successful. And I want to get the attention of those back in the lobby who represent special districts and higher education, cities and counties, any kind of public board. Because you have been silent about this bill. And the fact of the matter is, cities, counties, special districts, higher education, I know you have been silent about this bill. I do not know why you have been silent about this bill. I don't know why you have refused to engage on this, but let me say to you that most surely, whether you want to admit it or not, back in the lobby, you tell your clients, you tell them now, you tell them that Representative Bob Gardner said in the well, you're next. You are next. Your lawyers will be next. And if you think you can dodge, and you think you're not going to have this fight and probably lose it next year, because the argument will run like this. We already do this for school boards. It's no problem. We already do it. You know, and it hasn't been a problem for them. And so those little water districts and those little metro districts, those little municipalities who already have a difficult time getting people to serve are going to find that they too will have to record their attorney-client privilege communications. And I want to say this one more time to those of you back in the lobby, you will be next. This bill is about a lot of things in my mind. It's about the fight between an education association, an education reform movement. That's what it's really about at its core. But it will be the example, and it will be the guiding light for those who want to attack their municipalities. I think I said the other day, you know, the lawyer side of my brain already is calculating the legal fees that one can make off of this deal. And that ought to give all of you here pause. It certainly gives me pause as I represent my constituents. And so let me say, between seconds and thirds on this bill, CCI, CML, Special District Association, higher education, you will be next. And if you aren't engaged on this bill for the good of the order, if you will, shame on you as well. It is disappointing to me that you are not engaged on this. It is disappointing to me that you do not protect the attorney-client privilege of another public body, that you do not make your sense of what ought to be sense of threat known. Because I believe, based on what I've seen on this bill in the past here in my 8 years, is that when you engage on this, it's not just school boards. It becomes every public body in the state, including the state public bodies. And I am waging this battle and this fight to protect not just the privilege for school board members and school boards of education, but for all of those other entities. But I will not be there if you aren't there now. Do not stick your head in the sand. Counties, cities, special districts, you are next, because there are those who would invade your attorney-client privilege. Mr. Chair, I appreciate your indulgence in allowing me to make the reasonable inferences from what I have heard here, and it is a more than reasonable inference that this is the beginning of a slippery slope. I think that's one of the favorite terms in this House these days, slippery slope. And it is a slippery slope. And for that reason, I ask for a no vote.
Representative Quorum.
Thank you, Mr. Chairman. It would be easy to stand here and look at, after listening to Representative Gardner, and say what he said. But I'm not a lawyer. I'm not an educator. I'm a simple country boy who served as a treasurer of a board of education in Montrose, Colorado. I served as the president of the Delta Montrose Vocational School. And my experience, I was elected to office, to the school board. They were in the middle of a horrendous lawsuit involving the firing of a former superintendent. That lawsuit was already underway. But we had many hours in executive session. And I think that that was imperative that we as lay people of the community who serve on those boards, we have to acknowledge and rely on that legal mind to take that away and to present a situation where our voice may be silenced because it is recorded, I think is a dangerous program to start. Now, in rural Colorado, we don't spend money like they do in the metro area getting elected to a board of education. Fact is, there's many positions on the boards that are unopposed. You simply do not have the people that have the time and the energy to serve on those boards. But if we put this roadblock in front of those people that think that what they say in executive session may be a matter of public record, I think is a very, very dangerous program. I think this bill is something that I am glad we've had the discussion. I appreciate Representative Penniston for bringing it forward. I think it's a discussion that we needed to have, but I think this discussion has borne out that this is a bill that is not ready for prime time, and I ask you for a no vote.
Is there any further discussion? Representative Gardner.
Thank you, Mr. Chair. And thank you, Representative Quorum, for bringing what is an important perspective of someone who receives this legal advice. Because what has always been interesting to me about these public meetings and then the executive session in which I'm asked to attend as a lawyer. First of all, boards typically are sort of reluctant to invite you because you don't do these things usually pro bono. I mean, that's how we make our living, and that's what we do. So even if we give them a preferential rate, it's still costing them money, and they're very concerned for very good reasons. Now, I think one of the problems that this bill is aimed at, as I've listened to the discussion here and heard what occurred in committee, I think one of the problems is that some school districts, when they go into executive session, have decided to bite the bullet and have their attorney present at all times. I don't think that's a bad thing. It may be more than is necessary, but it's not a bad thing. And in fact, if the school district is one that is engaged in a lot of high-profile activity bringing about change that may upset an association that represents teachers that collectively bargains with them, not only is it not a bad thing, it's a highly advisable thing. Because each and every comment and each and every discussion around any of those issues that are permissible executive session topics could very well call for legal advice. And as Representative Corum reminded me, I see my clients, when the recorder's running, being very constrained, even though I say to them, well, this is executive session, it wouldn't be released unless we went to court, unless we were drug into court. This is proper executive session material. I still see them as being constrained, concerned. When the recorder goes off, I get a lot freer questions, a lot more open questions and discourse with the board members. They feel freer to ask me what's really on their mind. And you say, well, they shouldn't be constrained. Well, they are. And we, at least some of us in society, I become concerned when my colleagues who are members of the bar don't agree with this. I do become concerned. We have always said that we believe that providing good, solid legal advice in an open environment between attorney and client is a positive public good. I become concerned when I see this assault on the privilege. And once that recorder goes off, I've heard some things that I wasn't going to hear otherwise, and I've headed off some problems for clients by saying, I know that's what you think, but if you do that, it probably doesn't play well. And I might say it doesn't play well politically. It's perfectly legal. When I give advice as an attorney and I give political advice, that is advice about a legal matter about which my legal advice has been sought, and I say to someone, you can do that, it just is going to be very difficult for you. Is that legal advice? I think so. I think so. But I wouldn't want to be second-guessed about that. You know, the assault on the attorney-client privilege has taken place with lawyer lobbyists. mean, there's a case out there where a lawyer lobbyist engaged in a communication with a client, and I believe it was attorney-client privilege, but a federal court said otherwise. And it's just astounding to me. And knowing that that case is out there in that context makes me wonder about how this would play out at the courthouse. And as I started to say when I was here before in the well, for these particular districts at which this bill, I believe, to be aimed, I believe they will undergo an assault on every piece of attorney-client privilege communication they have in executive session. Every piece. I think they will be in court, and I think there will be a judge assigned in the 18th Judicial District who does nothing but listen to recordings of executive sessions of school boards. I hope it's the right one who has respect for the attorney-client privilege, notwithstanding what his or her views may be on the issues, because this is not about whether the conduct of the board is right or wrong, their particular course of action is good policy or bad policy. It is about the question of whether school boards can get advice that is not constrained in any way, and they can ask questions and make statements to their lawyer that are not constrained in any way. And let me say it one more time. We have regarded that forever and always in the Western and Anglo-American legal system as being a positive good because it yields more good, far more good than harm when people receive unconstrained legal advice and can ask questions of their attorney without any constraints or concern that what they ask and what they say and what they discuss will further be disclosed. And let me say one more time for those of you who may have floated in and out of the lobby, those of you who may have clients who are associations or members of associations that would be defined as a state public body in the Open Meetings Act, counties, cities, special districts, higher education, which has provisions in the Open Meetings Act especially for it to try to protect its attorney-client privilege. Let me tell you, I don't want to promise you because it's not me that's going to do it. Let me warn you, you are next. As this bill proceeds, as I fear that it will, from second to third reading and from this House to the next, let me give you some advice that is not privileged, because I say it here in front of all of the citizens of Colorado. Let me say to you a piece of advice. You need to advise your clients that they may well be next. And if they choose to be silent about this bill, because it only involves school boards and it won't happen to us, or we'll fend it off when it happens, guess again. Guess again. If you don't have that conversation with your client today, if you haven't already, I'll simply say I think you are remiss. And if they hear it and disregard it, I think they are remiss. Because it won't be forever that somebody can stand down here for an hour and make this difficult. Representative McNulty won't be here to articulate next year in such an erudite, logical, and calm way what the dangers are for these public bodies. Now, were it to me, I would stay here the rest of the day and into the night, because this issue is that important. You might ask yourself, why is Representative Gardner choosing this bill of all bills and this time of all times to spend so much time in the well? Well, it's not just because. It is because this bill, more than any that has come before us, in my view, is so much an assault on public policy that it deserves the debate. It deserves, for the record, for people to know. Deserves for everyone here who's not paying attention except sporadically, and I'm not critical of that, I do likewise. And for those of you in the lobby who are lobbying someone and talking amongst yourselves, but don't hear except when you look to see what's going on, it deserves that in all of this time you hear what the danger to public policy and public decision-making in Colorado is. I know that the sponsor of this bill, a friend and colleague, is well-intentioned. I know she believes it to be the right and correct public policy. I respectfully but vehemently disagree. It will set us on a course of less advice about public decision-making. It will set us on a course of constrained questions and advice. And so for that reason, I ask you, all of you, each of you, reconsider. Ask your cities. Ask the Colorado Municipal League what they would think about a bill that did this to our city attorneys. Ask CCI what they would think about a bill that would do this to county attorneys. Ask your special districts how they would feel about this bill if it was done to the special district, because that is, members, for those of you who are going to be here, I make you a small wager. This bill will be back in another form for all of those entities. It's not going away. Reminds me of that adage about when they came for your neighbor. Well, they came for the school districts, and they'll come for you next, public bodies. You ought to wage the fight. You owe it to everyone. I ask for no vote.
Representative Buck.
Thank you, Mr. Chair. And I think House Bill 1110 is so important, and I'm just so grateful that the Estes Park Elementary came today to hear the discussion, and I thank them. Thank you, Mr. Chair.
Thank you, Representative Buck. Representative Peniston.
Thank you, Mr. Chair, and thank you to everyone who was up here and was part of this vigorous debate. Thank you for all the rest of you for bearing with it. Last comment. Public school boards of education meetings are a time where public discourse should be welcomed and encouraged. Taxpayers should be able to hold the school board members and their processes accountable, but sometimes citizens are being shut out. This accountability cannot be done without transparency. I truly believe this bill will give our communities more information on which to base inquiries, and less fishing expeditions will be needed. I ask for your yes vote on House Bill 1110.
Seeing no further discussion, the question before us is the passage of House Bill 1110 as amended. All those in favor say aye. Aye. Those opposed, no. No. House Bill 1110 passes. Mr. Kohler, please read the title of Senate Bill 19. Hold on, Mr. Kohler. Assistant Majority Leader Pabon.
Thank you, Mr. Chair. I move Senate Bill 19 lay over until the end of the calendar.
Are there any objections? Seeing none, Senate Bill 19 will be laid over as requested by the Majority Leader. Mr. Kohler, please read the title of House Bill 1030.
House Bill 1030, Representatives Quorum and Mitch Bush, also Senator Schwartz, concerning the establishment of incentives for the development of hydroelectric energy systems.
Representative Quorum.
Thank you, Mr. Chair, and I move House Bill 1030 and the Transportation Committee report.
Thank you, sir. To the Transportation Committee report. Representative Mitch Bush.
Thank you, Mr. Chair. We do move that report, but we also move an amendment to that report. That amendment is L009, and I believe it will be displayed properly in a minute.
The amendment is properly before us. Please proceed.
Thank you, Mr. Chair. Amendment L009 came out of a stakeholder process which was agreed upon in committee between the three stakeholder groups that we've been working with. That was the Small Hydro Association, the environmental community, and the electrical community.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L009 to the Transportation Committee report. Those in favor say aye. Those opposed, no. The ayes have it. Amendment L009 passes. To the Transportation Committee report. Representative Quorum.
Thank you, Mr. Chairman. You know, we did a lot of work on this bill. This is an interim Water Committee bill that came out of this summer. The main thing that we did on it was we deleted Section 3 of the bill, some cleanup language along the way, but it's a great bill, and vote yes.
Is there any further discussion on the Transportation Committee report as amended? Seeing none, the question before us is the adoption of the Transportation Committee report as amended. Those in favor say aye.
Aye.
Those opposed, no. Transportation Committee report as amended passes. To the bill. Representative Quorum.
Thank you, Mr. Chairman. Once again, I ask for your support on the House bill and the committee report, and ask for a yes vote. Thank you.
Representative Mitch Bush.
Thank you, Mr. Chair. This bill was the result of a full stakeholder process. It will help create rural jobs, and it will save rural folks, especially people in ag, on their electric bills. And it was great to work with Representative Quorum.
Representative Lawrence.
Thank you, Mr. Chair. And on this very important hydro bill, I'd just like to point out the fact that we have Pine Lane Elementary in the balcony, and they are very focused on renewable energies for Colorado.
Seeing no further discussion, the question before us is the passage of House Bill 1030 as amended. All those in favor say aye. Aye. Those opposed, no. House Bill 1030 as amended passes. Madam Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You have heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Kohler, please read the report of the Committee of the Whole.
Mr. Speaker, Committee of the Whole begs leave to report as in consideration of the following attached bills being second reading thereof and makes the following recommendations thereon. House Bills 1030 amended, 1110 amended, passed on second reading in order gross placed on the calendar for third and final passage.
Representative Salazar. You've heard the motion. There is an amendment at the desk. Mr. Kohler, please read the Priola amendment to the report of the Committee of the Whole.
Representative Priola moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following McNulty Amendment L010 to House Bill 1110 to show that said amendment passed on the House Bill 1110 as amended passed.
Representative Priola.
Thank you, Mr. Speaker. And members, you might need a little refresher on this amendment. It was ran.
Can you please move the amendment?
Oh, I
How many
move.
years have you been here?
The amendment to the Committee of the Whole report. Priola amendment to the Committee of the Whole report.
Thank you. Now proceed, Representative Priola.
Members, you might remember the amendment that Representative McNulty ran about a week, I think, whenever the bill was up.
2 days ago.
2 days ago before it got laid over. A very good amendment. I know in our discussion with Representative Gardner and others that transparency was a big issue. Well, this amendment really helps do that far more than piercing the attorney-client privilege only for lawyers that represent school boards, in that this area that school boards touch on, that they usually use executive session for, roughly touches on about 70 to 80% of their budgets. So I think if we're serious about transparency and understanding what drives and how the inner workings are, especially of school board budgets and the negotiations that I assume can go on for hours and hours and hours and hours, this is a good amendment to support. And this will go a long way to creating that transparency that I'm sure Representative Peniston really wants. I ask for an aye vote.
Representative McNulty.
Thank you, Mr. Speaker. Thank you, Representative Priola. Colleagues, with this amendment, you have the opportunity to make the following choices. Will you stand with parents, students, teachers, or will you stand with big labor and collective bargainers? Will you stand on the side of transparency, or will you stand in the back vapor-filled rooms? Will you open the bright sunshine to these contracts, these collective bargaining agreements, or will you leave them shrouded in secrecy, scant from the public eye, public disclosure, public review? The choices are simple. It is clear-cut. Those are the options in front of us. I, for myself, will support the Priola amendment and stand with students, parents, and teachers. I will stand on the side of transparency and against the smoke-filled rooms. And I will stand on the side of shining a bright light on these collective bargaining contracts and on the side of transparency and public view. Colleagues, I hope that you will stand with us on the Priola amendment to the report of the Committee of the Whole. I ask for an aye vote.
Representative Peniston.
Thank you, Mr. Speaker, and I just very simply and respectfully ask for your no vote on this amendment.
Thank you. Any further discussion? Seeing none, the question before the House is the passage of the Priola amendment to the report of the Committee of the Whole. Mr. Kohler, please open the machine and members proceed to vote. What's going on, Mr. Kohler? Blame Mr. Kohler then. Representatives Duran, Giroux, and Szabo. sergeants know where she is, but they don't. Representative Szabo excused and fined $5. Close the machine with 26 aye votes, 37 no votes, 2 excused, and 0 absent. The Priola amendment to the report of the committee whole is lost. The question before the House is the adoption of the report of the committee whole. Mr. Kohler, please open the machine and members proceed to vote. Representative Rosen, close the machine. With 62 aye votes, 1 no vote, 2 excused, and 0 absent, the report of the committee whole is adopted. Ah. Hey, don't. Having a good day. Members, so you know, for afternoon or committees, committees will meet starting when we get off the floor, morning committees till 3 o'clock. Afternoon committees will start at 3 o'clock. So expect some time. You guys are going to be here. Madam Majority Leader, or announcements and introductions actually first. Madam Majority Leader.
Thank you, Mr. Speaker. I think they may have given up on us, but I did have some students up in the gallery from Grandin School in Boulder, and I welcome you if they're there, and if they aren't, I hope they're listening, and let's all welcome them.
Representative Sonnenberg.
Thank you, Mr. Speaker, and members. I think the Ag Committee will take a break during lunch and go to the Association of Wheat Growers. But in case we don't, you're all invited to the Masonic Temple across the street and have lunch with the Colorado Association of Wheat Growers. Thank you.
Representative Kagan.
Addition to tomorrow's House Judiciary Committee calendar, House Bill 1173 for action only.
Representative Court.
Thank you, Mr. Speaker. Okay, Finance Committee members, in case you weren't listening to the Speaker, I hope you're listening to me. 3 o'clock across the street, same bills, same drill.
Representative Fisher.
Thank you, Mr. Speaker. Members of the House Agriculture, Livestock, and Natural Resources Committee, we'll start committee at exactly 11:35 down in 107. We have witnesses that are on a tight time frame for having to catch planes and so forth, so please be prompt.
Representative Singer.
Thank you, Mr. Speaker. House Local Government, we'll see you bright and early at 3 p.m. with House Bills 1143, 1177, 1161, and 1221.
Any other announcement? Representative Hamner.
Thank you, Mr. Speaker. House Education Committee, we will meet in 10 minutes. See you there.
Seeing no further announcements, Madam Majority Leader.
Thank you, Mr. Speaker. I move to lay over the balance of the calendar.
Seeing no objection, the balance calendar will be laid over until tomorrow. Representative Duran.
Thank you, Mr. Speaker. The Joint Budget Committee will resume at 1:30.
Okay. Madam Majority Leader.
Thank you, Mr. Speaker. I move the House stand in recess until 1 p.m. this afternoon, at which point we will adjourn until 9 a.m. tomorrow morning.
Seeing no objection, the House will stand in recess until 1 p.m. tomorrow. Have fun in committees this afternoon.